Your Honor, it seems like you're practicing law from the bench. I'm gonna respect your courtroom, but I disagree. On what grounds, Your Honor? Because I never got served directly.
If you stop speaking when I'm speaking, then I will state my grounds.
There's no contract with Amitai Bay and Carrington Mortgage in this matter, right?
Sir, I'm not going to explain my ruling to you.
In this video, we dive into the bizarre courtroom antics of a Moorish sovereign citizen attempting to represent himself in a foreclosure hearing. From driving during a Zoom court session to making wild legal claims, it's a chaotic spiral you won't believe. Here is the interaction.
And sir, you are Amitai Bay, is that correct, sir?
Yeah, Amitai Bay, real party and interest in this matter.
Okay, are you driving a vehicle right now while you're on the hearing?
You said I'm driving a vehicle. Yeah, you need me to stop? I mean,
I need you to stop, sir. I can't have you driving
give me
while
15 seconds. I can pull it back up to my family house, and I'll stop.
No, I can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm pulling up parking now. I'm parking, right? 5 seconds. Okay, I'm done, Your Honor. For a second. I'll call y'all when I get back.
Okay, this matter is scheduled for a hearing.
Do you recall in reviewing your business records if a foreclosure was conducted with regard to this property?
Yes, it was.
Objection, Your Honor, hearsay.
Okay, overruled. You may respond, sir.
On what grounds? So I could maintain the error for the record when I appeal this, if this don't go accordingly.
Okay, it's a business record, sir. That's an exception from
first-hand knowledge. Was he there at the closing table?
Doesn't need to be, sir.
Your Honor, it seems like you're practicing law from the bench. I'm gonna respect your courtroom, but I disagree. I would disagree as tremendous. So,
okay.
Court reporter, can you please note that the honorable judge, I'm stating he's practicing law from the bench without fact.
Your objection is part of the record, sir. All right, you may continue, Mr. Dewhurst.
And is this a true, correct, and complete copy of the sheriff's deed of mortgage foreclosure, to the best of your knowledge?
To the best of my knowledge, yes.
And is this sheriff's
Objection, Your Honor. Can he vow to that under penalty of perjury? That's the original document.
Your Honor, he stated this to the best of his knowledge.
No, under penalty and perjury, can he contest that that is the original document with the wet blue ink signature? Penalty and perjury.
All right, sir, that's not the question. The question is whether he can identify the document.
Under penalty and perjury, can it be yes?
Sir, you have to stop interrupting.
Penalty and perjury.
You can make an objection, but once you've stated your objection, you have to stop. All right.
And for the record, Your Honor, I do have counsel coming for this next court date. They obtained, as soon as he get back in the country, he will be jumping in to take care of this matter further. So I'll ask you just give my counsel some time before any permanent decision is made so they can review these books, all interrogatories, so we can make a fair decision. Because I'm not arguing it's a debt, and I've been trying to honor the debt, Your Honor. I'm not arguing that it's a debt. I done did everything possible to honor this debt. They have not been in compliance with it.
And Your Honor, I would object to that, given this would be our third hearing, and he had ample time to get counsel.
Objection again.
All right, let's take one issue at a time, gentlemen. I can't be expected to remember 3 or 4 objections all at the same time. I'm going to overrule the objection on the basis of a business record exception. As to the request to adjourn the matter for Mr. Bay to retain counsel, I'm going to deny that request. Mr. Bay is
on what grounds, Your Honor? Because I never got served directly.
If you stop speaking when I'm speaking, then I will state my grounds. And so
I never requested that. You stated that, Your Honor. This is my first time requesting any adjournment to bring in incredible counsel who can handle this matter fairly on my behalf.
At this point, I don't even see that you have standing to participate in this case, although I guess we will get to the proof on that issue. So,
so Your Honor, you don't have my deed of records right there. You don't have me as the deed owner. You don't have me as a certificate owner in the record. I put all that on the record. So for you to say I don't have standing is kind of unfair from my understanding.
And was that redemption date September 27, 2021?
Your Honor, he's coercing. He coercing Mr. Dewhurst.
The government record and or document recorded with the applicable recorder of deeds for this this document.
Okay, any objection to that, Mr. Bay?
Absolutely objection.
Okay, and what's the basis for your objection?
He's a third-party debt collector. He's not a real party in interest, and he has no firsthand knowledge of any of the affairs that took place with this mortgage or at this closing table. And that Mr. Dewhurst he's not eligible to bind a corporation. Do he have the status of a CFO or a CEO in that company?
Okay, so the objection is that this witness doesn't have the
firsthand knowledge to any other matters.
Okay, all right. So the objection is overruled.
And has Carrington ever conveyed any of their ownership?
Objection, Your Honor. Objection.
What basis, sir?
Rightful owner as the title, rightful owner as complete ownership of the property. Can't just take away my interest like that without facts. You guys still have not had no verification of debt. What you have in your hands, Your Honor, you don't reached out. They cannot verify that debt, and they cannot verify that they ever loaned Rachel Brown and Matthew Brown any money for this mortgage. They can't. They can't prove that, and they haven't yet. And I've been waiting. I just want to know if they're a real party in interest, are they a real creditor in the amount, so we could handle any financial obligation if owed. They are yet to prove that. Like you said, I got the deed, and it's sealed by the county records. I have the warranty deed as well, and it's sealed by the county records. Objection. Can you prove I didn't redeem and attempt to redeem? Can you prove that it hasn't been corresponding and negligence on you guys' behalf?
Overrule the objection.
Yeah, the property was foreclosed on and Carrington took control of it.
Okay.
Objection, Your Honor. How can you take control over something that I got the taxes in my name? I've been staying there the last year, and I have the deed and the warranty deed again for the record.
May I ask a question that would help?
You may, Mr. Johnson.
Objection, Your Honor. He's about to coerce him again. The question was clear. He could answer that on his own. He said he had 30 plus years of experience. This shouldn't be his first rodeo. He can answer that on his own.
Was there any redemption made by any party during that time?
No.
And none of your reflect.
Objection.
None of your record.
Objection.
And once again, you have not.
What's your objection?
That's not credible. That's not credible.
I'm sorry. This is not your time to ask questions, Mr. Bay. Mr.
Okay,
Johnson,
let me know when I'm credible to ask questions.
All right. Mr. Johnson, any other questions?
Has Carrington ever conveyed ownership of the subject property to any party?
No.
Thank you. No further questions, Your Honor.
Objection, Your Honor. So was Rachel Brown and Matthew Brown not the owner at the time that they
Mr. Bay, this is your time to ask questions. So if you want to ask any questions to Mr. Dewhurst, you may ask questions to Mr. Dewhurst. Okay,
Mr. Dewhurst. Is it not law that 15 USC 1692 G requires verification of any debt?
Your Honor, object as to relevancy.
Again, okay, what's the relevancy, Mr. Bay?
I'm establishing bounds for fraud. And since there's no statute of limitation for fraud, I'm going to make sure if they're not the original creditor, that it's fraud.
You didn't respond to the relevancy or how this is relevant.
The relevancy of 15 USC 1692 G, it binds any corporation or anybody who's saying there's a debt or a balance to verify it.
Okay, so this is the time to ask questions, not to argue law.
No, I'm not trying to. I'm asking the question. That was a question.
You have a question regarding the facts for Mr. Dewhurst. Okay, you may proceed.
Yes. So again, Mr. Dewhurst, under 15 USC 1692 G, do you have to verify a debt?
I'm going to have to object again regarding relevancy, Your Honor. This is, unfortunately, he does not have standing to bring any claims of verification.
Objection. I'm a real party in interest. Objection, Your Honor. He doesn't have any standing. He hasn't proven he's more than a third-party debt collector yet.
Your Honor, after the foreclosure period ran,
Your Honor, we don't know if this is credible foreclosure. Can I ask my questions, Your Honor?
All right, gentlemen, you cannot speak at the same time.
Next question. So, Mr. Dewhurst, are you conscious of the verification of that letter that been sent to you, to your company twice, that I sent with behalf of Matthew Brown and Rachel Brown that they're yet to respond from. My notary sent it. The notary republic sent it.
Your Honor,
Yes.
I would have to object.
Yes or no?
Sir, you have to let Mr. Johnson state his objection. Mr.
Okay, I'm
Johnson,
sorry.
what's your objection?
Your Honor, she's asking the witness to respond to a vague request if he has any notice, but, you know, I would ask that he would only ask as it relates to the business records, Your Honor.
Objection, Your Honor. I sent that to the Business and Record Department, and I sent it attention to the CFO of the company.
No, Your Honor, I'm not aware of it.
But that's an argument. That's not a question. This is a
Okay.
time for questions.
No, that was in the form of a question. You didn't let me finish, Your Honor.
Okay, well, you can't ask multiple questions within the same question.
Okay. Well, Mr. Dewhurst, what was the problem answering the verification of that letter? If you have that in the record. So we've been asking for the original.
Objection, Your Honor. He stated that he was not aware of a letter.
You're right. Correct. So I should say then, moving forward, is there a problem producing the original contract with the wet bluing signature from Rachel Brown and Matthew Brown? If you have that in the records.
Okay, so you have a question for Mr. Dewhurst?
Yes, Mr. Dewhurst. Is it fair to say you cannot prove that the original, you don't have access to the original copy of the note of the mortgage?
Yes, I'm
Under
sure.
penalty and perjury, do the company have it, Mr. Dewhurst?
So you may ask another question.
And okay, also, for you, Your Honor, so it's also credible and fair to say he has no firsthand knowledge of anything as well.
Okay, so that's an argument. That's not a question. Okay. So yeah.
All right, I'm learning. I'm sorry, Your Honor. Thank you for your patience. So Mr. Dewhurst, under penalty and perjury, can you confirm that your company followed all GAP procedures with this process?
Objection, Your Honor.
Understandable. So I guess the last question, again, I just want to confirm that Mr. Dewhurst, you have no firsthand knowledge of the of Carrington Mortgage being a creditor in this loan for this mortgage. So that's still kind of broad, Your Honor. I want for the record for him to say, are you guys the creditor, or you don't know?
Objection, Your Honor. Asked and answered.
No, that's not asking and answer. I'm asking directly. Mr. Dewhurst, is Carrington Mortgage, can you confirm they're the creditor of this loan or this note, or you don't know? And I'm asking that for lawful reasons.
And so by bidding the highest in the sheriff's sale, what interest does that give Carrington then in this proceeding?
Within the creditor.
Okay. All right.
Allegedly. So that is true if that's the case. But if Your Honor or court, if Carrington can never prove they ever issued anything, is it fair or is it lawful to state that they never have the right to say they hit with the highest bidder with anything?
Any more questions for Mr. Dewhurst, Mr. Bay?
Not at this moment, Your Honor.
Okay.
Not at this moment. I'll let my counsel deal with that.
Okay. Does the plaintiff rest?
Yes, Your Honor. But if I may just conclude with a couple of things, if that's okay.
Well,
objection, Your Honor. Statement and brief from counsel is sufficient for summary judgment.
And to show that there was indeed a foreclosure sale conducted on March 25th, 2021.
Objection, Your Honor.
And this is final argument, so that you can't object to that.
I'm sorry, Your Honor.
All right. Additional final state arguments, Mr. Bay?
Yeah, again, Your Honor, you know, he's wasting judicial resources coming with this because, again, I have proof on file and on record, correspondence. We try to resolve this matter. At this time, I would like to bring my counsel in. They'll be back in the States in a couple of weeks. And also, Your Honor, can I request that Mr. Johnson put his bond on file? Can I get his bond information, his liability bond for this matter as well?
Okay, no, that's not an issue in this case.
And if not, I ask for you to just honor my motion, honor my counterclaim to dismiss this matter, because they don't have, it's not nobody with real party and interest on this line right now. Nobody with firsthand knowledge is on this court case right now. that can speak and contest to what's going on. So with that being said, I ask to adjourn this matter or dismiss this matter because for failure to state a claim upon which relief can be granted.
An individual who's identified himself by the name of Amate Bey claims to have a possessory interest in the property, though he did not present any proof on the record today of any interest that would make him have standing to contest this mortgage foreclosure and this suit for possession. So based on the proofs on the record, the court does find that Carrington Mortgage Service LLC does have the right to possession, and therefore a judgment of possession against Amate Bey and all occupants of the premises is granted.
What is my time frame to no, can you just for the record, so there's no contract with Amate Bey and Carrington Mortgage in this matter, right?
Sir, I'm not going to explain my ruling to you. I just ordered that the Carrington Mortgage would have the right to get an order of eviction on July 5th, removing all occupants from the premises.
That's fine, Your Honor. I'll make sure it get overruled in a higher court. Thank you.
Okay. All right. That's all for the record. Thank you, gentlemen.
Thank you,
Your Honor. Have a nice day.
You as well.